I came across a couple more videos, so now this prompted this video that I am doing right now, and it's by the group the Peacekeepers. At the helm is Brian, who is still pushing the challenge where he's looking for the originating document between the people and government, which gives government the force over the people. And I sort of did, a soft shoe uh, approach to it and thought I put this matter to rest, but of course the pledges are still accumulating and to provide the hook that will bring someone forward to bring this originating document. And so in in um, in response to this, I have now written a few things down succinctly so we can put this matter to bed and that we can then move on to what is really important, and that is locating our true freedoms. Okay, I have it titled "Prove the Obligation: Peacekeepers Challenge." And first of all, I'm going to make an offer. Of course, that's what the proper construct of a contract that you put out there. You put out an offer to consider, and once that consideration is done, then you have formed an agreement. Well, I'm going to make a counteroffer within that with that initial agreement, um, which is this: I will accept 10% of the entirety of the pledge and surrender the rest to how you guys want to distribute it, with the hopes that you will use the remaining 9% to then start getting the people that are following your program and your platform to just simply study what law is, to finally come to some comprehension. Okay? So, prove the obligation? Well, here's the immediate answer to this. Okay? There will never be anyone who can produce any conclusive originating document that forces upon any individual a duty to pay council tax or be obligated to perform any act under government which evidences an act that is contrary to one's absolute right that allows one to make a free will choice. Because there can never be any evidence of an originating agreement which includes any individual under the laws of nature and natural law within a class of people and next then include a fiction of law called Parliament. There is only ever contracts and trusts between legal personages, not living people, and fictions of law. And so one has to be first using a legal personage initially to have any rights noticed in English law and equity. I will not only 100% prove this, besides just using English law to then reference equity, but also by using the process of syllogistic reasoning, basic common sense, and the entirety of all public statutory acts, case law, definitions, and commentary that will then arrive at evidence through the through the public annals of court record, and to which that has been discussed in all under legislation and then also discussed in the jurisdictional courts. This information, which I could provide, will serve to actually free the people from the mind trap of locating equitable relief of some sort of equitable relief of some sort against a juggernaut who has no interest in an individual's absolute rights, but only those relative rights established within society through a legal capacity as a tenant for life, to which is then annexed to a status such as a citizen. And you can find that in Blackstone commentaries under absolute rights of persons. Okay. Now let's first identify 3 points as to build our base, and which is then that will then through the process will help us arrive in a concrete a concrete definition of what we are agreeing to through the process of deductive reasoning. And here are my 3 main points. First of all, English law is the evolution of rights to the use of land as a tenant. Secondly, a tenant is a capacity, next, subject to a status, a legal personage, so a perpetuity vehicle. And thirdly, a status must be realized to then be with the right to hold an interest in land under English law. With those as our three main points, let's continue. No one can be seen in English law without first being limited to the capacity of a tenant for life and next using a particular status. It is the only means in which English law can affect any action within its rules, because there has to be a prescribed duty and power so that the courts can begin to determine each party's obligation to the issue, so as to then afford the use of the appropriate law in order to effect the correct remedy under the agreement that the parties are both subject to by their very own actions within said jurisdictional court. Man is with right of dominion. This is without argument. Dominion of man, those of absolute right discussed in natural law, obviously cannot ever be considered in English law for three very logical reasons. Number one, there is no way the absolute right of dominion can ever be confined in order to then not commit thereafter fraud according to natural law and free will. So it's obviously against the law. Secondly, there is no means in which to establish certain powers and duties to restrict that which is with absolute rights without being in a contradiction in terms. There has to be a perpetuity vehicle, so a legal personage, namely, so as to carry forward a continual agreement that is not prone to a mortal life. And thirdly, English law can only govern rights to lands in which are directly associated with the status of the individual, so as to assign the appropriate law according to the jurisdiction formed through the concept of consubstantiality, namely, the life of full age, according to full age, necessary to form a binding agreement through first the capacity of a tenant for life, which is next annexed to a status that then affects a particular subject matter so as to establish proper jurisdiction for the courts to adjudicate over. Read and reread this, as this just defined proves that there is no immediate obligation between Parliament and the people. It is impossible according to English law. Man has absolute rights. Man gives up this right for relative rights. Relative rights are those rights that command what is right and prohibit what is wrong within a society of men. Again, you can look that up easily through Blackstone's commentaries. Slavery is abolished. If this is true, and it is expressed in law that slavery is abhorrent to English law, then how could it ever be possible that any man is made to participate in any obligation against his will, without being originally against the law of men? Common sense, right? It is rather this absolute truth, this absolute tenable fact, that man does not know anything about his own agreements. He is yet acting under his own right and yet he is not acting under his own right and being 100% responsible, and why he is equipped with a limited liability vessel used in equity, within a society of men, that he then subsequently confuses as having an absolute right under a limited liability agreement according to his proven status and subsequent actions. Just have a drink here. I think my voice is getting dry. He then is perplexed why he is being forced into an obligation within each independent, systemic, limited liability agreement, whereby he is obviously being measured against the performance of other actions within said society that solidify those relative rights and so overreach absolute rights, to which then this agreement to relative rights personifies and secures what the majority are obviously in agreement to by notice of all of their very own actions within this same society. This agreement then overreaches his absolute rights by the very simple and logical fact that without honor in our agreements among men, we could never rely on any production or be secured in our own labor ever. So why the agreement must serve as the basic priority over those absolute rights of men. Law is not equity. Peacekeepers do not know what law is. They say it every time they speak. It is a common epidemic, albeit purposely designed this way. So I'm not faulting them personally. And this is so exclaimed emphatically by now asking for pledges to act as a hook for proof of the originating obligation in equity. It is in law, not equity, okay? Thereby then proving that they are not at all speaking to the absolute rights of men, but rather fulfilling the agreement by their current displayed public actions concerning the territorial law subject to the equitable rules over action. So nothing to do with law at all. Do you see the absolute insanity of this? One cannot use the same mind that is responsible for creating the problem initially to then solve the problem while it is the problem itself that he is initially reliant on, so as to keep his legal personage alive within the society that then creates the problem. And then we have people fight within this choice by picking and choosing what they want to do and not want to do. Not as a man and woman, but as a citizen who is evidence of a tenant and an assumed owner of land held under a trust, so subject to the rules of equity, not English common law or natural law. It is Parliament who is granted the right to administrate over the land's use. In other words, is given the rules through patent to fulfill its obligation to control the waste made upon the land while in use. Parliament does not own any land. They have a use only, thereby creating legislation against this contract, as would any employer who has established their particular type business. And so logically, they each create rules that control citizenry or their employees to meet a predetermined outcome, and so to be in honor of its proprietary agreement in equity. Are you a citizen? Are you making purchase under Parliament? Do you make agreements through the bar union? Are you agreeing to being a tenant? Are your very actions evidencing that you have given up your absolute rights to enjoy relative rights? Are you under a single legal personage, like a country, which is responsible to create legislation over the rules that the majority are tacitly in agreement to? Are you clamoring for democracy, which is mob rule? Now, albeit the mob is ignorant of what law is, what equity is, what government is, money. Essentially, they don't even know what the agreements they make know that they then enforce every day by their own actions. They are obviously participating under the rules of government. The beginning of 2020, we just went through the irrefutable evidence of people being controlled by an invisible enemy, which shut down the majority, locked them in their own homes, put face diapers on them, had them volunteer to roll up not only their sleeves, but the sleeves of their own lineage for an experimental chemical cocktail of corporate greed, which, by following the money, proves it is an operation like any other government position to support its economic purpose through funding a commercial interest, so as to fulfill the obligation of world governments. And, by the way, there is no such thing as a living or killing virus in nature. For, if there was, the species of man would not even be here today to speak of it. Okay? Government educates through the fiction, the legal personage, and so has nothing to do with the living being. Did you know that government cannot patent nature, only what it creates itself through its own creation and its own regulated science? And the virus is under patent. Every strain is, which are concepts. They're not even real. Everything is an agreement first, so not of nature, but of the minds of men who want to control land. And so why we have English law and equity. Now, from just what I have evidenced thus far, does it not prove that there is no obligation against any individual unless they are first noticed to be of a particular status, and so has to be annexed to a particular subject matter that must evolve from an initial land interest first. Harvard education document provides a glossary of English law terms. I'll attach to a link, which I'll attach a link to this video, defines the common law as such. It says, the judge-made law of England received by the United States in the 18th and early 19th centuries, the common law of a state's and future interest, is normally thought to include the common law statutes of de donis, clia emptoris, usus, and statute of wills. There is no agreement as to what date should be regarded as the cutoff for the common law, but in the field of estates and land and future interest, common law normally refers to some period before the statutory reforms of the middle decades of the 19th century. Unquote. Note the word used. The common law of estates and future interest. Where does it say the people? And next it uses the word agreement when it states there is no agreement as to what date should be regarded as the cutoff for the common law. What has to be established before any definition can be ascertained according to the subject matter, before matter being questioned? There obviously has to be agreement. Bill of Rights 1688 reads, to which Mark and Brian both shared, to then next overlook a key word within the text itself, to which they then read publicly. By glossing over this word, they inadvertently or purposely propped up their mandate that the people have a right over government. Well, here's a hint. There has ever been any direct contract with the people in Parliament. As I've already stated, it doesn't exist because man cannot deal directly with a fiction without using a legal personage to do so. Like you cannot effect an action in court without using a vessel of equity. And next, for the historical traceable fact that government was created through monarchy. And the rule of law is that the creation cannot be greater than the creator. Compounded with the indisputable truth that it states within the 1680 Act itself that the monarchy is no longer absolute owner of all land when removing everyone as being automatically subject. And so one now has to be in agreement to be construed as directly subject, otherwise you are granted citizenship under government. Or you have expressly removed yourself from the assumption of the agreement of being subject or being a citizen. The 1688 Bill of Rights succinctly reads, well, I'll first read what it is that the Act is for. It states, an act declaring the rights and liberties of the subject. So what do you got to be first? And settling the succession of the crown. The preamble, to which both Mark and Brian have read, or more so, Mark has read, it states, whereas the Lord's spiritual and temporal, well, who are the temporal? Are they not the serjeantry, the lords of yesteryear? And commons. So, sorry, I should just read it first of all and then make any comments I want to after the fact. It says, whereas the Lord spiritual and temporal and commons assembled at Westminster, lawfully, fully, and freely representing all the estates of the people of this realm. Do I need to read any more based on what I've just expressed? If we just quickly look back up to that definition provided through the Harvard Education Institute, where it states the judge-made law of England received by the United States in the 18th and early 19th centuries, the common law of estates and future interest, is normally thought to include the common law statutes, blah, 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 blah. And then we go into back to the preamble, which states that it represents all the estates. So how are we not then concluding that in order for us to be seen in common law, anything being seen in common law, it has to be through estates first? Can't be through agreement between people and Parliament. You can't have that. It's it's like a corporation cannot be represented unless through a bar union member. You can't do it. It has to be this first before the people can interact. It's government is interacting with the estates that are an interest of the people, but not directly with the people themselves, because that's what the monarchy does. The monarchy is the direct, or is the direct, I guess, vehicle that the people use through an operation of law, to which then have a confidence in the monarchy holding that common law, which is relative to those estates' interests that then the monarchy grants for the government to use. Okay? We have an intermediary. We can't go directly to government if you want to be noticed of being of absolute rights or dominion rights. You have to go through the monarchy that then speaks to government, because you can't go directly to government without that intermediary being that confidence in the monarchy holding the common law. And I'm going to further develop that by just speaking briefly to the history of the feudal land tenure system. Okay, and I wrote this, so you can look to yourself if I'm being correct in this. But William the Conqueror, A.D. 1066, created tenures based on a military structure to then divide lands and chattel. He conquered the land, not the people. Yes or no? Certain statuses were assigned land tenures, to which were immediately subject to the prerogative of the king, who held all land, as in kinship, like as in any group agreement, so in a title, not in an individual noticed in natural law. Anyone who was not immediately of certain status, and so relegated to certain performance through allegiance, was not seen in the common law. Only those who held the idea of freeholds, so those who had rights to non-freeholds, such as villenage and copyholds, or those of perpetuity, such as the corporation, the Roman Catholic Church, or the ethnic group called the Jews, were not or could ever be seen in English common law. Rules of equity follows the law. In fact, this is equity's very own law maxim. So, meaning the law is before equity. The English common law is before uses and trusts that are managed through the rules of equity. So, not only is the law a different subject matter than equity, but equity is a byproduct of not having a right to a common law state because of a status or of a corporation or of ethnic origins. The original English common law estates, still existing because of settlement of land acts, are not an interest of government and or corporations and or citizens and are those agreeing to be subjects, because lawfully they are a different subject matter, each one of them, and through the law of repeals can never be commingled. Now, you can look this out and source this out in your own interpretation acts. It will succinctly say that you can only repeal laws of the same subject matter. Equitable estates only overreach a common law interest if the common law interest is first a product of an equitable interest, subject to a use of trust, because logically and lawfully they must be of the same subject matter, which means we are speaking to the territorial common law and not the foundational English common law, in order to ever consider to be in conflict with one another. Thereby, and only, can equity overreach that same territorial common law, but can never overreach the foundational English common law because, again, they are both different subject matters. The English common law's legal state can never be overreached since the church, so I'm just going to, I guess, obviously expand on this more. The English common law's legal states can never be overreached since the church, the Jews, Parliament, national treaties, international governments, organizations, etc. are obviously not only notification of perpetuity instruments, so it can never hold a legal estate in common law, as they are not born of nature, namely, but also Parliament can only ever have rights to administrate over the second level of use to land, which is governed under the rules of equity, not the common law held in the monarchy or those interests held by the lords temporal. So not the constitutional monarchy, since this entity, this new legal personage, has no right to the common law interests now held in each individual, classed under the term people. All beginning with the Bill of Rights 1688 and settled in the Bill of Rights itself, which clearly states, and we'll do it again so we can inculcate it into our minds, is that whereas the Lords spiritual and temporal and commons assembled at Westminster lawfully, fully, and freely, representing all the estates of the people of this realm. Every law book, every act of legislation, every judicial determination is relative to the status and subject matter so as to not commingle law and equity through the assignment of a definitive jurisdiction. At least we can begin to agree on this besides the preponderance of evidence I so provided in this video, that a court action cannot move forward unless it first has not only the correct parties, but those parties which can be heard within a certain determinable jurisdiction. So, in closing, there is no obligation, there is no contracting, there is no original agreement between the people and government. And it doesn't exist because it would go against the very nature of law and equity for the reasons I have already aforementioned. Now please share this video to put this untenable task to rest, as it is as futile as blaming a unicorn fart for the smell in the room. Okay? It does, though, to serve, but, I will have to say, by bringing this matter forward, it does serve to bring the truth to us, which is inherently what we're trying to seek, is where do our original rights begin and where do they end? Okay? Now, of course, not only share this video, but please pass on to both Mark and Brian if they are really interested in the truth for the benefit of all. Because, you know what, I have also experienced many others who do not care for the truth, but rather to maintain their own platform that they have built, albeit even though it was all built upon a house of cards in a sea of distortion, thereby arriving in a realization that they are acting no different than the government they are fighting against by keeping these ideas together and continually to have people support them based on the very fact they don't even know what the agreement is. I'll let you decide if I prove that there is what that obligation is, okay, and whether I'm not worthy to command the right to those pledges based on the public agreement they are said to honor, of which they also extend that same concept of honor to those who have pledged. So again, we're looking at an honor-based system, which is essential for all of us to able to deal with each other effectively. And with that, I remain, and so close this video that now definitively proves there is no originating obligation except through each individual's own agreements to serve under under the Lord's spiritual, temporal, and commons, and so under government and its contractual obligations with the monarchy, who holds the rights settled in the English common law. Thank you for listening, and please like if you did.